Good day and welcome to episode 7 of Stratagem LP's Legal Podcast. This is the podcast where we review case laws and discuss topical legal issues, allowing our audience to stay updated on the law while on the go. Whether you are driving at home, working out, or relaxing, we've got you covered with insights that help enhance your legal knowledge. In today's episode, we are delving into the constitutionality or otherwise of President Tinubu's declaration of a state of emergency in Rivers State. In the wake of the said declaration of a state of emergency in Rivers State on March 18, 2025, there has been widespread debate over the legality and constitutional validity of the said declaration. In a nationwide broadcast, President Tinubu announced the suspension of the democratically elected governor of Rivers State, Siminalayi Fubara, and the state's House of Assembly, replacing them with a sole administrator. This move has sparked significant legal discourse regarding its constitutionality and the effect it has on state governance. In this episode, we will critically examine the President's declaration vis-à-vis the constitutional provisions surrounding the declaration of a state of emergency, particularly focusing on Section 305 of the 1999 Constitution as amended. We will explore whether the President acted in accordance with the Constitution and the broader implications of this declaration on the state governance and constitutional democracy in general. Before delving into the specifics of the March 18th declaration, let's first define what a state of emergency means. According to the Chambers 20th Century Dictionary, a state of emergency refers to the suspension of normal law and order procedures, where strict controls, often involving the military, are introduced to manage a crisis or revolution. While the 1999 Constitution of Nigeria does not explicitly define a state of emergency, Section 45(3) of the 1999 Constitution, as amended, provides clarity by defining a period of emergency as any period during which the President has proclaimed a state of emergency pursuant to Section 305 of the Constitution. Section 305 outlines the procedure for declaring such an emergency and the conditions under which it can be invoked. Furthermore, Section 45(2) of the Constitution allows for the suspension or derogation of certain fundamental rights during an emergency, as per Chapter 4 of the Constitution. Essentially, a state of emergency is a drastic measure where normal governance is suspended to restore peace, security, and order in exceptional circumstances. Now, let's discuss the constitutional requirements for declaring a state of emergency. According to Section 305, subsection 3 of the 1999 Constitution as amended, the President can declare a state of emergency under specific conditions. A. When the Federation is at war. B. The Federation is in imminent danger of invasion or involvement in a state of war. C. There is a breakdown of public order and safety requiring extraordinary measures to restore peace. D. There is a clear and present danger of a breakdown of public order and safety. E. A disaster or natural calamity affecting part of the community. F. Any public danger that threatens the existence of the Federation. G. A request by the governor of a state in accordance with Section 305, subsection 4. It is clear from the above that the President's power to declare a state of emergency is not arbitrary. Section 305 outlines specific criteria that must be met for such a declaration. Historically, declarations of states of emergency in Nigeria have often been based on public order, public safety, and security concerns, such as during the 2013 emergency in the Northeast states under President Goodluck Jonathan. Unfortunately, the 1999 Constitution, the Interpretation Act, and the Public Order Act did not define the phrase public order. Thus, whether the crisis between Governor Fubara and the House of Assembly constitutes a breach of public order is not clear. In the instant case of Rivers State, President Tinubu declared a state of emergency due to a political crisis involving Governor Fubara's alleged continued prevention of the State House of Assembly from functioning and subsequent governance paralysis. The lack of cooperation between the governor and the legislature, combined with militant activities, led the president to invoke his constitutional powers. This raises the question, does the impasse between the governor and the House of Assembly amount to a breach of public order as specified by the 1999 Constitution? What are then the procedures for declaring a state of emergency? The procedure for declaring a state of emergency is outlined in Section 305 of the 1999 Constitution as amended. The first step is for the President to issue a proclamation published in the Official Gazette of the Government of the Federation. The second step is the transmission of this proclamation along with details of the emergency to the President of the Senate and the Speaker of the House of Representatives. They are required to convene their respective houses to decide whether or not to approve the proclamation. Section 305 subsection 4 provides further procedural details allowing the governor of a state to request the president to declare a state of emergency if there is a breakdown of public order or safety within the state. However, in the case of Rivers State, President Tinubu's declaration was made without such a request from the governor. Instead, the president acted independently, claiming that the crisis was severe enough to warrant federal intervention. What are the implications of the declaration on state government functionaries? The key question now is whether a declaration of a state of emergency automatically displaces state government functionaries. The answer is not entirely clear. While past declarations of emergency have resulted in the removal of state governors, deputy governors, and legislative bodies, the 1999 Constitution does not expressly provide for such actions in the event of a state of emergency. A closer look at Section 305 reveals that it emphasizes a cooperative relationship between the federal and state governments during emergencies. Section 305(4) even empowers the governor to initiate a state of emergency, suggesting that the Constitution does not contemplate the removal of the governor during such a situation. Moreover, the president's proclamation suspended the governor and the House of Assembly in a manner that contradicts the removal procedures outlined in sections 188 and 189 of the 1999 Constitution as amended, which specify the circumstances under which a governor can be removed, including impeachment or permanent incapacity. Sections 188 and 189 are crucial to the discussion, as Section 305 begins with the phrase "subject to the provisions of this Constitution." It follows, therefore, that Section 305 is subject not only to Sections 188 and 189 of the Constitution, but also to other relevant sections of the 1999 Constitution as amended. The Supreme Court has interpreted the phrase "subject to" as used in the Constitution in the case of Balong and others versus Governor of Anambra State and others, reported in 2009 Law Pavilion Electronic Law Report 729 SC, Pachukuma Ene JSC, Dosley, and I quote, "The use of the words subject to in the provisions of the subsection have conjured up a condition, a restriction or limitation, otherwise governed, subordinate, or subservient to. In the case of Rivers State, President Tinubu claimed that the governor's administration had effectively collapsed due to the ongoing crisis between the governor and the state legislature, specifically the House of Assembly. To restore governance, the president appointed a sole administrator to take charge of the state. Let us critically look at the president's personal intervention in the Rivers State at the early stage of the crisis before the declaration of the state of emergency. President Tinubu, in his declaration broadcast, spoke about his personal intervention in the crisis between the governor and the lawmakers at the early stage. In his words, and I quote, "I have made personal interventions between the contending parties for a peaceful resolution of the crisis, but my efforts have been largely ignored by the parties involved." However, it is important to note that contrary to the president's claim in his proclamation broadcast, Governor Fubara did not ignore the president's intervention. Upon the president's involvement, Governor Fubara withdrew his defenses in the case filed by the pro-Wike lawmakers to pave way for amicable resolution of the dispute, which the president has initiated. But the lawmakers ignored the president's intervention and proceeded with the case until they obtained a judgment in default of defense against Governor Fubara. It is the same judgment that was affirmed by the Supreme Court in February 2025. What's more perplexing is the president's statement after the Supreme Court judgment, urging Governor Fubara to obey the rule of law without reprimanding the pro-Wike lawmakers for disregarding his intervention by proceeding with the court case to judgment. In conclusion, President Tinubu's declaration of a state of emergency in Rivers State appears to be unconstitutional based on the provisions of Section 305 of the 1999 Constitution. The case highlights the delicate balance between the federal intervention during emergencies and the autonomy of state governments in the Nigerian constitutional federalism. As history has shown, the declaration of a state of emergency is a powerful tool, but it must always be exercised in accordance with the tenets of the Constitution. Thank you for listening to this episode of Stratagem LP's Legal Podcast. I remain your principal host, E.B. Ochuma, Esquire. My special thanks to my review assistant, Miss Oyinda Mola Daramola. Join us next time as we continue to explore the legal issues that shape our society. Until then, stay informed, stay empowered, and keep learning. Thank you.